Good evening, all. Welcome to the webinar series of Mehta and Mehta Insolvency and Restructuring LLP. And today's topic is the recent amendments in IBC laws and Bhushan insight into Bhushan Power Steel case. Friends, as you know, recently there are few amendments after long. Otherwise, earlier it was used to be lot of amendments frequently. But there is a change now. So after long, we are getting amendments. So we are discussing first of all that. It is into IP agency, into liquidation regulation, into inspection investigation. So that all different and voluntary liquidation as well. So all that we will discuss. And in addition, we'll discuss the case of Bhushan Power and Steel with what we learn as a IP and insolvency professional. Of course, it is still under a different forum and it is still subject to its temporary stay at present. But still, what we have to learn as an insolvency professional, we are going to discuss that. So, with us today's our panelist is Mr. Ravi Granthi. Mr. Ravi Granthi is well-known personality, is always there and all IPs know him. Actually, don't need any introduction, but for formality, I'm introducing Mr. Ravi Kanti is a BTech IIT, MBA, and LLB. Very knowledgeable, very highly educated. Welcome, Mr. Kanti. His corporate experience is of more than 35 years across various industry and with various functions. He has held board and CEO level positions in two listed companies. He is into insolvency practice since 2017 when initially it started. He is an early starter that all seniors. He is currently liquidator of group of 9 corporate debtors in real estate. Oh my God, real estate sector, most difficult sector, and one in dairy sector. He is advisors to RPs and liquidators in various matters. He is a regular faculty in courses conducted by IP agency. Welcome, Mr. Ganti. Thanks a lot for your time. Yeah. With us, Mr. Also John, our partner, John Vincent is there of IPMTT. He is having a long career, is more than 25 years experience in Indian banking sector, specialized in insolvency and distress asset management. And as a registered insolvency professional, he is also having IBC knowledge and he is actively contributing to the various seminars, including ICICI IP and written articles. Welcome, Mr. John. With this,
Yeah, very good evening.
Thank you. Our today's presenter is Ms. Disa Pandya, the research head of Mehta and Mehta. And with this, I will request if Mr. Ravi want to say a few words on the topic, and then Ms. Disa can start the presentation. Over to Mr.
Thank you, Diptiji. Thanks for inviting me here. Enjoying always such sessions because when we attend them, all of our knowledge increases. We ask questions of what we don't know, we get various viewpoints, and each one of them will go to enriching how we perform our assignments better in future. So thank you very much, and that's all I want to say. We can start the session.
Yeah, Disha.
My screen is visible, right?
Yeah, make it full screen.
Yes.
Yeah.
So, good evening all. So today, as ma'am said, we are going to discuss on the recent amendments under IBC regulations and a landmark judgment on Bhushan Power and Steel case law. So the first amendment of 29 January 2025 is of Insolvency and Bankruptcy Code of India of model bylaws and governing board of insolvency professional agency. So in this, they have amended the schedule in para 4, clause 12A for the authorization for assignment, that is known as AFA. So in that, in subclause 3 in proviso, they have extended the time period for the renewal from 45 days to 90 days before the date of expiry of the authorization. And in subclause 5, if the authorization for the assignment is not issued, renewed, or rejected by the agency within 15 days of that receipt, the authorization shall be deemed to have been issued or renewed. So here also they have extended the time from 15 days to 90 days. The second amendment is on the inspection and the investigation. Was notified on 29 January 2025. So the first was the regulation 2, sub-regulation 1, subclause C. Disciplinary committee means a committee of a whole-time member constituted by the board and under section 1 of the section 220 of the code. In this proviso, they have said that the whole-time members in the DC shall not be associated with the investigation or inspection. So, what is meant by associated? The explanation is inserted that a clarification had been added regarding the term associated, defining that it to include involvement in the conduct or investigation or inspection, consideration of the investigation or inspection report, or issuance of show cause notice. The third amendment is related to grievance and complaint handling procedure on 29 January 2025. So in the amendment, there is on regulation 3, filing of grievance and complaint. So they have insert in regulation 3, in sub-regulation 4, in the proviso, after the word shall not exceed 30 days, the amendments they have added from the date of closure of all the proceeding related to the process under the code before the adjudicating authority, the appellant authority, the High Court or the Supreme Court, as the case may be. The fourth amendment on the voluntary liquidation. So regulation 33 related to liquidator to realize uncalled capital and unpaid capital contribution has been omitted. In regulation 39, corporate voluntary liquidation account, first you have to maintain an account with the public accounts of India. Now you have to open an account with a scheduled bank. So they have given the various inserted new regulation 41A for filing of the forms. So the first form is VL1, which has to be filed on the 10th day of the second month after the public announcement, including the corporate person details and the voluntary liquidation process detail. VL2 has to be filed on the 10th day of the subsequent month after meeting of the contributories or replacement of the liquidator, detailing the reason for the delay and the meetings. VL3 has to be filed on the 10th day of the subsequent month after the submission of the resolution application or the withdrawal, suspension application, covering the unclaimed proceed, realization, pending litigation, etc. And VL4 is to be filed by the 14th day after the order of dissolution or withdrawal, suspension of the voluntary liquidation process, detailing the distribution of proceeds and payment. So if there is any delay in filing the form, so there is a penalty of rupees 500 per form per month of the delay will be charged for the late filing. Liquidator may face action including the refusal or the issue of AFA for non-compliance, delay or filing of incorrect, incomplete information. In Form G, which is related to in that deposit of unclaimed dividend or undistributed proceeds, they have added the information which to be given related to applicable section of income tax, amount of tax to be deducted, and reason for unclaimed dividend or undistributed proceeds. So the amendments related to the liquidation process, was there on 29 January 2025. Regulation 45 of final report prior to dissolutions. So liquidator shall submit an application along with the final report and the compliance certificate in Form H to the adjudicating authority for the closure of the liquidation process of this corporate data, where the corporate data is sold or going concern. In that, they have also added the compromise or the arrangement, which has been sanctioned under Section 230 of the Companies Act 2013. And Regulation 46, as we see in the voluntary liquidation, same with the liquidation, you have to open an account with the scheduled bank instead of the public accounts of India. So here also Regulation 47B has been inserted related to filing of the forms. Liquidation 1 form is to be filed on the 10th day of the subsequent month after the public announcement. All the details related to liquidator, corporate data, fees, etc. has to be filed in the public announcement. Liquidation 2 form is related to the progress after the 10th day of the subsequent month after each progress report submission covering valuation, sale, litigation, transaction, etc. And liquidation 3 has to be filed on the 10th day of the subsequent month after the submission of resolution closure application, including the details of unclaimed proceed, distribution of asset, etc. Liquidation 4 form has to be filed on the 14th day after the order of dissolution or the closure of liquidation. So the same penalty is there for non-filing. 500 per form per month of the delay will be charged for the late filing. And the liquidator may also face the same action, including refusal to the issue or renew of AFA for non-compliance, delay, or filing of incorrect or incomplete information. So in Schedule 1, related to mode of sale, in that auction, some of the clauses are amended. So Clause 1D, related to the public notice, has been omitted. Clause 1E, the liquidator shall provide to prospective bidder access of the asset under auction to facilitate their inspection and the due diligence. This has been added instead of the at least the 7 days criteria has been removed. And new clause 5A is inserted. The public notice shall state the prospective bidder and shall submit an undertaking that they do not suffer from any ineligibility under the section 29 of the code to the extent applicable, and that if found ineligible at any stage, the EMD shall be forfeited. After clause 12, the following clause has been inserted. So in clause 12A is that within 3 days of declaring the highest bidder, the liquidator shall conduct the due diligence and verify whether the eligibility of the highest bidder. The liquidator shall prevent the auction result, details of the highest bidder, and the due diligence conduct on it to the consultation committee. The liquidator shall also declare that the highest bidder as a successful bidder or reject such bid after consultation with the committee. If bidder is found ineligible, the EMD by him shall be forfeited. In case the highest bidder is found ineligible, the liquidator may, in consultation with the consultation committee, declare the next higher bidder as a successful bidder after following the same process as provided from clause 12A to 12E. So in this Form I, deposit of unclaimed dividend and undistributed proceed, they have asked for the additional information related to the Income Tax Act, whichever section, and any law, amount of the tax to be deducted, and reason of unclaimed dividend or undistributed proceeds. So this is an amendment related to mandatory use of this Banakit for an equity auction platform for liquidation on 28 March 2025. So IBBI issued the circular dated this or before in 10 January 2025, directed all the IP handling the liquidation process to exclusive use this Banket auction platform, formerly which was known as IPRE, for conducting the auction of the sale of asset during the liquidation process with effect from 1st April 2025. But further, IBBI also, by its circular dated 28 March 2025, also directed IPs to exclusive use the auction platform for conducting the auction for the sale of asset during the liquidation process, mentioning the following in the auction notice. Prospective bidder shall submit the requisite document, including declaration of eligibility under Section 29A of the IBC through electronic auction platform. Prospective bidder shall deposit the EMD. It shall also specify that if the bidder is found ineligible, the EMD shall be forfeited. So on the regulation related to insolvency resolution process for corporate person, on 3rd February 2025, new regulation for 4E, handing over the possession, has been inserted. That after the obtaining the approval, not less than 66% of the total votes, the resolution professional shall hand over the possession of the plot, apartment, or building, or any instrument agreed to be transferred under the real estate project, and facilitate the registration where the allottee has requested for the same and has performed his part under the agreement. Regulation 16C is related to appointment of facilitators. If the number of creditor in a class exceeds 1,000, a subclass of at least 100 creditor can request the appointment of facilitator. The total number of facilitators shall not exceed 5. The fee of the facilitator is 20% of the fee payable of authorized representative, and it will be the part of insolvency process cost. So what is the role and responsibility of the facilitators is mentioned in Regulation 16D, facilitating the communication between the AR and the creditors, attending the meeting of the committee, observers, communication between the creditors of the respective subclass, provide the information and clarification to the creditors in subclass about the insolvency resolution process as advice of the authorized representative, and other tasks assigned by the committee to improve the representation and communication.
Granthi, this subclass means a particular in real estate, particular real estate or area tenants, or like that way you refer that kind of.
No, this subclass here refers to any group which need not be homogeneous. It
Acha.
is expected that if it is, we are talking of 1,000 plus allottees. So it is a large project. Naturally, it will have many towers or whatever. Okay. So it is expected, though it is not specified because it doesn't have to be. It could be one tower is one subclass. It has to be 100. Okay. Or it could be 2, 3 towers together becomes one subclass. So subclass here means actually a subgroup would have been the right word to use. But subclass has been used because class of creditor, no? So,
yeah, because that's why it is means subclass means you carve out among that same, some class of thing and then.
it is actually subgroup. The meaning is subgroup.
Yeah. Okay. Okay. Thanks. Yeah, Lisa, go ahead.
So Regulation 18 is related to meetings of the committee. After sub-regulation 3, the following has been inserted: that when CD has any real estate project, the committee may direct the resolution professional to invite the competent authority as defined under the Section 2 of Real Estate Regulation and Development Act 2016 related to such project to attend such meetings of the committee, as the committee may decide without voting rights for providing inputs on the matter associated with the development of such project. Regulation 30C is related to the report on the status of development, rights, and permission of real estate project. When the corporate debtor has any real estate project, the resolution professional shall prepare a report detailing the status of the development rights and permission required for the development of such project, submit the report to the committee for its comments, and submit to the adjudicating authority the report to along with the comments of the committee referred to in clause or on or before the 16th day of the insolvency commencement date. Regulation 31 related to insolvency resolution process costs. So as we discussed before, fee of the payable to facilitator is also to be included in insolvency process costs. Regulation 36A is invitation for expression of interest. In the detailed invitation referred to in sub-regulation 3 shall provide the details of corporate data registration status as micro, small or medium enterprise in accordance to MSME Act 2006. Provided that where the corporate data is any real estate project, the committee for an association or a group of allotee in such a real estate project representing not less than 10% or 100 creditors of the total number of creditors in class, whichever is low, may relax the following: eligibility criteria for submission of expression of interest provided in clause A above, and condition regarding the refundable deposits. Request Regulation 36B, request for the resolution plan. The new proviso is inserted after sub-regulation 4A. So the proviso is related by the corporate data as any real estate project. They may relax the requirement to provide for the performance security for an association or group of allottees in such real estate project representing not less than 10% or 100 creditors out of total number of creditors in class, whichever is low. So section
Mehta, go ahead. Go to earlier slide, Mr. Gandhi, can you this explain what it means actually?
See, when the resolution applicants are some of the allottees themselves, and that has to be minimum 10% of the total allottees or 100, whichever is lower. Okay. That they themselves want to put a plan that is effectively like doing the resolution on their own in self resolution. In such cases, both the EMD clause and the PBG clause can be relaxed.
Okay.
It can be totally waived.
Okay, thank you. Yes.
Regulation 38, mandatory contents of resolution plan. So in sub-regulation 4 and 5, they have made a omitted, and the new thing has been inserted that the committee shall consider the setting up a monitoring committee for monitoring and supervising the implementation of the resolution plan. The monitoring committee may consist of resolution professional or any other insolvency professional or any other person, including the representative of the committee and the representative of resolution applicants as its member, provided that where the resolution professional is proposed to be a part of monitoring committee, the monthly fee payable to him shall not exceed the monthly fee received by him during the CRP process. The monitoring committee shall submit quarterly reports to the adjudicating authority regarding the status of implementation of the resolution plan.
This last one is good one.
Yes, the last one is possibly the most important amendment that has come in a long time, because if this is there, something like Bhushan is unlikely to happen.
And if there is a issue in implementation, it can be addressed immediately, and all that can be happen. Both way it is. It's not anytime there is a ambiguity or problem in implementing also. So that can be taken by. It's a very important. It was required since long. Dish.
So this is a circular related to intimation to the board on the appointment of insolvency professional under various process under the code, which was come on 11 February 2025, that the IP are henceforth mandated to add the assignments to IBBI electronic portal upon their appointment in the following process and capacity: IRP under CIRP process, RP under CIRP, liquidator under liquidation process, liquidator under voluntary liquidation process, resolution professional under insolvency resolution for personal guarantor, bankruptcy trustee under the bankruptcy process for the personal guarantors, administrator under the insolvency and liquidation process of the financial service provider. An IP shall access the portal with the help of unique username and password provided to him by IBBI. And when the assignment is added and approved by the IBBI, the IP shall proceed with the subsequent compliances, including reporting requirements such as public announcement, EOI, and the auction notice, except applicable under the different processes outlined in the code. The timeline for filing of assignment shall be as follows. New assignments, as all the cases commencing from the date of issuance of the circular, the IP shall add the assignment to the designated system within 3 days of his or her appointment. In the case of ongoing, For all ongoing cases where the assignment has not already added, the IP shall add the assignment by 28 February 2025. And the closed cases, for all the closed cases where the assignment had or not already been added, the IP shall add the assignment by 31st March 2025. However, for the closed cases related to personal guarantor, the assignment shall be added by 30th April 2025. Disclosure of information related to carry forward of losses and information memorandum. So all the insolvency professionals shall include a dedicated section in the IM detailing the carry forward of losses under the Income Tax Act 1961. This section shall prominently highlight, but it is not limited to the following aspects: the quantum of carry forward of losses available to the corporate debtor, a breakdown of these losses under specific heads as per the Income Tax Act 1961, the applicable time limits for utilizing these losses, and if there are no carry forward of losses available to corporate debtor, the information memorandum should specify the fact. So amendment in the insolvency professional regulation, if it's a qualification and experience, regulation 5, in that they have given the additional time of 24 months for passing the liquidation insolvency examination before the date of his application or enrollment for with the insolvency professional agency. From 12 months to 24 months, the time period is extended. Second, amendments on the insolvency resolution process for the corporate person. Form H has been substituted. The revised compliance provide a comprehensive detail of resolution plan process, which will be facilitate the adjudicating authority in taking the prompt decisions. The third amendment related to corporate person, which was there in recently 19th May 2025. Regulation 40B related to filing of the forms has been there. CP1 is for the commencement of the CIRP till the constitution of the COC. This has to be filed by the IRP. Timeline is on or before the 10th day of the subsequent month after filing the report on the constitution of COC to AA. CP2 is for the constitution of COC till the issue of RFRP. This has to be filed by the resolution professional on or before the 10th day of the subsequent month after the issuance of RFRP. CP3 is details of resolution plan, liquidation, closure application filed with the A. This has to be filed by the resolution professional on or before the 10th day of the subsequent month after the filing application with adjudicating authority. CP3B is for the approval of resolution plan, liquidation, closure by the A. This has to be filed by the resolution professional within 7 days of disposal of application by adjudicating authority. CP4 is related to avoidance of transaction reported to adjudicating authority, has to be filed by resolution professional on or before the 10th day of the subsequent month after filing of the application with the adjudicating authority or disposal of application by adjudicating authority. CP5 is a monthly. This includes the updates of the status of CIRP, details of COC meetings held, updates on litigations, details of expenses incurred, reason for delay, if any, etc. Has to be filed by the IRP or RP on or before the 10th day of every month for the preceding month. So the penalty is rupees 500 per form per month of delay, which will be charged for the late filing. So how the implementation of the revised CIRP period in transaction period will take place. For CIRP admitted on or after the 1st June 2025, the revised form shall be applicable. For CIRP that are ongoing as on 1st June 2025, the existing form CIRP1 and CIRP2 forms have now been converted into CP1, and the existing form CIRP3 and CIRP4 forms have now been converted into CP2. The new CP1 and CP2 forms are required only if the corresponding earlier CIRP forms were not submitted. Accordingly, CP1 and CP2 2 forms are not required to be submitted in all the cases where CRP 1 and CRP 2, 3 and 4 forms were filed earlier. CP 3A, 3B, 4 forms are required to be submitted in all ongoing CRP cases. In cases of any form as per the revised framework stated in point 1 and 2 above is due for submission on or before 1st June 2025, such form are required to be submitted by 30th September 2025. Submit the first monthly CP form by 10th July 2025 for the period of June 2025 and thereafter to be submitted on monthly basis till conclusion of CRP. For CRP which is closed on or before 31st May 2025, where any earlier form remain pending as of the date of the circular, IP shall submit the corresponding form under the revised framework on or before the 30th September 2025. So the amendment in the personal guarantor to the corporate debtors regulation 19 May 2025. There is an insertion of a new regulation 17B, non-submission of repayment plan. When no repayment plan has been prepared by the debtor, under section 105 of the code, the resolution professional shall file an application with the approval of creditor before the adjudicating authority, intimating the non-submission of repayment plan and seek the appropriate directions. So here we have concluded all the recent amendments. Now we'll discuss the case law of Bhushan Power and Steel.
Disha, let's take some questions, if any, on the regulations till now. Then we can go to the case law.
Yeah. Anyone has any questions? I think people are digesting only, and because there are procedural aspect lot in this. All the forms are changed.
Yeah. So any questions from anyone on whatever has been covered till now?
I think.
Can they speak, or how is the questioning to be
Yeah,
done?
they can speak. Yeah, if they
They
want,
can
they
unmute
can
and
raise their hand and they can speak.
Okay.
Devang, Himanshu, anyone? I think no. No one is there.
Or otherwise they can put it in chat box also.
Acha, you are already put on chat.
No. He is saying you can put on chat box.
Yeah.
But
I think no one has questions. Yeah. We can,
okay.
Yeah.
Take right.
So the judgment was given by the Supreme Court of India on dated 2nd May 2025. The Honorable Supreme Court of India has delivered a landmark judgment in the case of Kalyani Trustco versus Bhushan Power and Steel. Court has set aside the order of NCLT, which had confirmed the order of NCLT approving a resolution plan submitted by GSW in the CIRP of the Bhushan Power and Steel Limited, the corporate debtor. So the fact of the cases were the CIRP proceeding were triggered against the Bhushan Power and Steel Limited at the instance of Punjab National Bank before the NCLT under the provisions contained in the IBC, which was admitted on 26/7/2017. The resolution professional admitted a claim in respect of the financial creditors and the admitted claim to the INR 6 crore 20
Limit the amount. Leave it. It's too big. You can carry on.
respect of operational creditors. The prospective resolution applicant, JSW, Tata Steel, and the Liberty House submitted their respective resolution plan. In the 18th meeting held on 14/8/2018, the plans submitted by the Liberty House, the Tata Steel, and the JSW were evaluated by the COC. And as per the evaluation matrix formulated by it, and the JSW was found to have scored the highest in the term of the said evaluation matrix. However, the COC did not declare H1 and H2. The COC e-voting resulted in the approval of the consolidated resolution plan as amended by the amending letter of the JSW by requisite majority of COC. On 14 February 2019, the resolution professional filed an application for the approval of resolution plan submitted by the JSW before NCLT. Pending the said proceeding, the CBI on 5th April 2019 registered an FIR against the corporator, its director, and other section 120B, read with section 420, 468, 471, 477A IPC, and section 113 subsection 2, read with section 1313 of the Prevention and Corruption Act. On the basis of the said FIR, the Directorate of Enforcement registered the case on 25th April 2019 for the offences under the Prevention of Money Laundering Act 2002. The NCLT, by its order dated 5th September 2019, dismissed the company application filed with the erstwhile director and approved the resolution plan of JSW. The successful resolution applicant, JSW, challenged some of the conditions mentioned in the said order passed by NCLT approving the resolution plan by filing the appeal, being the company appeal number 2957 of 2019 under section 61 of the IBC. After the approval of the plan by NCLT, as aforesaid, the Directorate of the Enforcement of Central Government (ED) passed a provisional attachment order under section 5 of PMLA. The said PMO have been challenged by JSW before NCLT, and NCLT state the PMO as well as the resolution plan so far it's related to the payment of creditor by its order dated 14 October 2019. The NCLT, imposed judgment dated 17 February 2020, reported at JSW Steel Limited versus Mahendra Kumar Khandelwal and others, approved the judgment dated 5th September 2020 and passed by the NCLT subject to the modification, clarification made by it in its impeached judgment. Appeals against the order of NCLT has been filed in the case. So what was the decision of the Supreme Court on the different thing has been discussed. An aggrieved person under section 61 and section 62 of the IBC. Section 62 of the Code contemplates that any person aggrieved by the order of NCLT may file an appeal to the Supreme Court on the question of law arising out of such order under this code within 45 days from the date of receipt of such order. It is interpretation of this provision that the Honorable Supreme Court, relying its earlier judgment in the matter of Glass Trust Company LLC versus Baiju Ravindaram and others, clarify that the expressions any person aggrieved is not confined solely to those who were parties to the proceeding before the NCLT and NCLT as the case may be. Once the CRP is initiated, the proceeding becomes a collective proceeding where all the creditors, ex-promoters, ex-directors of the CD also become the stakeholders. Thus, the expressions any person encompass anyone who has suffered a direct legal injury or whose legal rights or interests have been adversely affected by the order. The court has further clarified that to establish local standing under these provisions, the person must demonstrate a tangible or legal injury arising from the order in the question and not met dissatisfaction. In so far as the same is established, the appeal under section 62 may be validly invoked by such affected person, irrespective of the person not being the party to the appeal application.
I think here they made a good clarification who is a person aggrieved, any person. That is a right clarification they provide here. And also they are very rightly said that it is not just mere dissatisfaction. You have to say that what is a legal injury or prejudice system. Yeah.
Limited grounds for filing appeal before NCLT under section 61. Section 61, subsection 3 of the code stipulates the specific and limited grounds upon which an appeal may be preferred before the NCLT against an order of the NCLT. An appeal against an order approving a resolution plan, the appeal shall lie only if it's demonstrated that the approved resolution plan is in the contravention of the provisions of law or has not followed the due process prescribed under the code and related regulations. K. Shashidhar versus Indian Overseas Bank and others held that the jurisdiction of the NCLAT in such matter is confined to the ground mentioned under Section 61(3) of the Code. The NCLAT is not empowered to entertain or adjudicate upon the issues or grant reliefs in respects of the matter which are neither raised before the NCLAT nor form a part of the order under challenge. Mandatory requirement under Section 29A of IBC. In the instant case, as transpiring from the record, resolution professional had not submitted the compliance certificate in the prescribed form H of the schedule while submitting the company application before the NCLT seeking the approval of the resolution plan under Section 31, read with Section 36 of the IBC. In the said company application, the resolution professional had only reproduced the clauses of the resolution plan without submitting the compliance certificate as prescribed in Form H. Since the eligibility and ineligibility of the resolution applicant to submit the resolution plan goes to the root of the matter, it must, on the part of the resolution professional, to verify and certify the contents of mandatory affidavit filed by the resolution applicant, JSW, in respect of Section 29 were in order. CIRP timeline under Section 12 of IBC. Section 12 of the Code stipulates a strict limit of 330 days for the completion of CIRP, including an extension and the time taken in legal proceedings. Any resolution plan received beyond the statutory limit without a valid extension granted under the code is legally unsustainable. RP and COC must ensure that the process is conducted strictly within the timeline so prescribed or extension is as per the provision of the code, failing which the CD will push into the liquidation process. Compliance with Section 32 is an obligatory to the safeguard the rights of operational creditors. Section 32 of the Code mandates that the resolution plan must provide for the payment of debts of operational creditors in a manner no less than the amount they would receive in liquidation. And such payment must be made in priority to financial creditors. The non-compliance with this requirement renders the resolution plan illegal and unfit for the approval. Both the resolution professional and the committee of creditors must ensure that the resolution plan submitted strictly complies with the stipulates of the Section 30 Regulation 2 and any deviations must be adequately justified within the parameters permitted by the law. Implementation of the resolution plan by a successful resolution applicant. Nobody should be permitted to misuse the process of law or nor be permitted to take any undue advantages of the pendency of any proceeding in any court or a tribunal. The NCLT or NCLT and delaying the implementation of the resolution plan under the grab of pendency of proceeding has clearly proved the malafide and dishonest intention on the part of JSW in firstly securing the highest score, making misrepresentation before the COC, and then not implementing the same order under the grab of pendency of proceeding through the resolution plan was supposed to be an unconditional one, merely because the code is silent with regard to the phase of implementation of resolution plan by a successful resolution applicant. Neither the tribunal nor the courts should be given excessive leeway to the successful resolution applicant to act in a flagrant violation of the terms of resolution application plan or in the legislated manner. Fail to file application for the avoidance transactions. Supreme Court, particularly in para 64 of the present judgment, also highlight the statutory duty of the RP to file application for the avoidance of transactions in accordance with Chapter 3 of the Code. Whether NCLAT has any power of judicial review over the decision taken by the statutory authority under the PMLA. The Supreme Court has clarified the limits of NCLT jurisdiction in the matter concerning the status such as PMLA Act 2002. The Apex Court has clarified that the NCLT and NCLAT are constituted under Section 408 and 4010 of the Companies Act 2013 and not under the IBC. And the jurisdiction and the power of NCLT and NCLAT are well prescribed under Section 31 and 60 so far for the NCLT is concerned, and under 61 of the IBC so far NCLAT is concerned. Neither NCLT nor NCLAT is vested with the authority to exercise the judicial review of the matter falling outside the purview of the IBC or falling within the purview of public law. The PMLA Act 2002 being a public law, the NCLAT do not have any power or jurisdiction to review the decision of statutory authority under the PMLA. So the conclusion is the judgment and the orders dated 5/9/2019 and 17 February 2020 passed by the NCLAT and NCLAT respectively are quashed and set aside. The resolution professional has utterly failed to discharge the statutory duties under the IBC and the CRP regulation during the course of entire CRP proceeding of the corporate data PPSL. The COC had failed to exercise its commercial wisdom while approving the resolution plan of GSW, which was in absolute contravention of the mandatory provision of the IBC and CRP regulations. The COC also had failed to protect the interest of the creditors by taking the contradictory stance before this court and accepting the payment from the GSW without any supporting of GSW to implement its ill-motivated plan against the interests of the creditors. The SRA and GSW, after securing the highest score in the evaluation matters in the 18th COC meeting, submitted the revised consolidated resolution plan with the amendment under the grip of complying with the amendments made in CRP Resolution 2016 and got the same approval from the COC. However, GSW, even after the approval of its plan by NCLAT, willfully contravened and not complied with the terms of the said approved resolution plan for the period of about 2 years, which had frustrated the very object and purpose of the IBC and consequently had violated the CRP proceeding of the corporate data BPSL. The resolution plan of GSW, as approved by the COC, did not conform the requirement referred to in Section 30, subsection 2, the same being in flagrant violation and contravention of the express provision of the IBC and the CRP regulation. The said resolution plan, therefore, was viable to be rejected by NCLT under 31(2) at the first instance. The order judgment passed by NCLAT in allowing the company appeal of GSW and issuing the direction without any authority of law and without jurisdiction is perversive and liable to be set aside. So some of the learning for the insolvency professional is the strict compliance with the procedural requirement. Form H filing, Regulation 39. Filing of compliance certificate in Form H before the NCLT is mandatory before seeking the plan approval under Section 36 and 31(1). Failure to do so undermines the validity of resolution plan submission. Learning is always strictly adhere to the IPBI forms and procedural compliance timelines. Maintain a pre-submission checklist for the NCLT filings. CIRP timeline, Section 12 of IBC. The IRP failed to seek an extension beyond the 270-day statutory period of CIRP. The timeline under Section 12 are non-negotiable unless properly extended by the NCLT. Any delay must be proactively regularized through an application for the extension before expiry. Proper eligibility verification under Section 29A. RP to conduct the proper due diligence on resolution applicant eligibility under Section 20A. Conduct through eligibility check including NPA status of applicant or connected parties. Past violations, related party connection, cross holdings, or corporate will breaches, document finding for scrutiny, etc. Mandatory avoidance transaction investigation. No steps were taken to identify or initiate action on preferential undervalue or fraudulent transaction. It is a fiduciary duty under Chapter 3 to investigate the avoidance transaction. Failure to do so may lead to loss of recoverable value and the breach of duty. Feasibility and viability assessment. Regulation 39(2). The RP skipped analysis of viability and implementation capability of the resolution plan. RP should always assess the financial soundness and implementation strategy of the resolution applicant, projected cash flow, operational plan, and legal compliances, independent expert inputs where necessary. Protection of operational creditors. Operational creditors were wrongly paid after the financial creditors, violating the existing law. Ensure the priority payment structure comply with the applicable regulation, particularly regulation at the time of submission, and protection of interest of minority or operational creditor as per section 32.
Great. Any questions, participants? The participant is silent actually. I think many has read already or. Hi, Himanshu, you can speak, please. You can unmute and speak. Himanshu, raise the hand. Himanshu?
Can you change the setting from webinar to normal mode? Then maybe there is some problem with some people being able to.
Now everyone is allowed to mute. IT department allow everyone to speak.
Okay, can you hear me?
Haji, boli.
So, Gantiji, I would request you to give your final comment on this case, JSW Bhushan Steel, because it has a far-reaching implications. Though it is very clear that legally was and very truly given that judgment according to my understanding. But if we look at the global perspective, when we are talking about the inviting foreign people for participate in the big ticket resolution application, under that circumstances, how do you see the future of the kind of IBC in long term?
Okay. Before I try to share whatever my thoughts or views are, can you tell me what, in your opinion, is the negative fallout of this judgment, if any?
The negative fallout is that, anytime, suppose the resolution applicant will be at, jeopardy at or whatever you can say.
So who has been aggrieved by this judgment? After considering the entire thing, all the facts of the case, has the RA been unfairly treated, or have the creditors been unfairly treated? Who is the aggrieved party here? At the end of the judgment, after the
appreciate. See, at the end, we can always say, there are a lot of things that JSW had in fact made money out of this judgment also, even if they get out. But the thing is that the message will go to the general world that here Supreme Court can anytime, reverse the judgment, and whatever they have done it for the resolution applicant for the company, you don't know, you may have to get out at any point of time.
Okay,
this is
has the
the
Supreme Court in its entire judgment? Let us then now go to the reasoning, because then it is the reasoning that needs to be challenged. Outcome is final result is the outcome of the entire reasoning and logic behind it. So, which part of the reasoning is arbitrary or perverse or something? Forget about that Supreme Court is final. That is accepted. But one can still criticize the Supreme Court's judgment. There is no bar against that in a democracy. That is perfectly allowed, and there is nothing wrong with it. So, which part of it, which part of the logic used or the reasoning is, let us say, should not have been done, or maybe done in a different way?
Sir, my understanding, which I can just tell you in a layman's word, that today this judgment has come after 2.5, 3 years after the resolution is approved, and they have already started implementing. They have made a lot of investment. So, when there is a reasonable time lapse has already happened, under the circumstances when the resolution plan is still challenged, in that circumstances, the person who is going to apply for the resolution will have always, some doubt in back of this mind that, okay, the resolution plan is approved by NCLT, it can be challenged by NCLT, or it can be by Supreme Court after any number of years.
So, is the time factor the critical factor or the reasoning in the judgment?
Timeline is according to me as a critical factor, that after some time it should not be.
Anything which is wrongly done, as long as a reasonable time passes, should never be interfered with. Now I'm putting the other way. जानबूझ के कर रहा हूं. Okay. Because we keep looking at, maximization of value of asset without understanding what the phrase means. Then we say that, commercial wisdom of COC, again, without understanding what it ought to mean, which has been very well addressed in this judgment, what it means and what it should not mean. And we are saying poor SRA. Okay. Now, the SRA is one of the largest business groups of the country. All the IPs put together who are feeling, bit sorry for the SRA would be less than 1% of the total net worth of this group.
Correct.
They have access to possibly the best legal advice that they can get in the country. And I'm sure they have been getting it all along. They have been in business for decades. So they know business possibly better than most IPs, because most IPs don't actually come from a operating business background. We are, more compliance related. So, and the judgment has clearly laid down, step by step, one by one, what were the wrong things willfully done by the SRA. Willfully, okay, not oversight. Not by a misunderstanding of a provision of law which could have two interpretations. No, willfully. Now, this is the first thing. Let's look at it. You have your plan, okay? You get it approved and then challenge it yourself, which means like I want to play with white piece in chess. Then again, I will go to the other side and play with the black piece. JSW was never an aggrieved party in terms of even, approaching NCLAT. Because there was no part of the resolution plan which was set aside. If you look at the NCLT order, the so-called conditions which they put were all within any other RA would have just accepted it as it is, Here, naturally, the whole point, it looked very clear that the amount of money that had to be paid, now this is where really the commercial wisdom of the RAs come in, that by the time you get your plan approved, maybe the steel prices are on the lower side. So you say, let me wait for things to pick up. Okay. And so you wait for about 2.5 years, the prices rise, the margins become better, and then you say, okay, now I am willing to make the payment. Now the payment is made in a manner which is not as per the plan. The plan which is finally approved is not the one on which they actually scored in comparison with others. Okay. Then non-disclosure of 29A. 29A is a what do you call that? It is a Lakshman Rekha. You can't cross it. Simple. If you are not eligible, you are not eligible. It doesn't matter who you are. See, ArcelorMittal faced it. Let's go back to SR Steel.
Right, right.
They faced the same problem and they had to cure that defect by paying off the entire Uttam Galva and the other, there are two companies. Okay. So they had to do that. Now that is available here. Here there was a flagging of the relationship, and that was something which needed to be addressed. They could have challenged it saying, no, we are not related, and let that be. But what happened was it was conveniently overlooked, glossed over, and after some time saying, okay, a lot of time has gone, chalo chhod dete hain. Now, the principle in law by which, lapse of time you give relief is actually not available to corporates. Such things, courts might give, indulgence or leniency when weak individuals, especially weaker section individuals, are involved, which could be, anybody who doesn't have the wherewithal to fight. Okay, you can't, give exemptions from law to somebody who is so rich or so available with everything, so they can't. Okay, so does it mean law is different for different people? It always is. It has to be stricter for those with resources. जो बलशाली हैं उनके लिए थोड़ा सख्त होना चाहिए. So in terms of, now comes the international impact that a lot of people say. Okay, I look at it as the most positive international impact that can ever happen. It is a signal that the rule of law still prevails in India. People cannot get away with murder just by delaying things and then saying, oh, अब तो हो गया, आदमी मर गया, अब क्या करना है? No. You say, sorry, it can be reversed. Okay. Okay. Now comes the economic impact on the corporate debtor itself. There is no economic impact. The plant was running during CRP, the plant was running post CRP, in the same manner, with no difference whatsoever. Now, as far as investments, okay, what is the investment? The 19,000 crores paid to COC members, which is with an undertaking that they will refund it. So there is nothing, no loss to A. Now, there, of course, more fallout that somebody who has deliberately done such a thing. Okay, they have the right of appeal. I mean, they can file review and whatever comes out of it. But at the end, it is not important it is JSW or Bhushan Steel or anybody. What is important is that the rule of law has to prevail, and certainty comes. See, it is not 2.5 years which is uncertain or 3 years which took. Because in a country where small cases, okay, especially let's look at the criminal law, where if the maximum punishment is 2 years, somebody is, incarcerated, awaiting because they cannot pay bail for more than 5 years. Now, under trial problem in India is 1,000,000 times bigger than the problem of corporates. Corporates know how to take care of themselves. So we, as IPs, I always feel this a bit funny. Why are we talking about somebody who is 1,000 times bigger than us? यार बेचारा, वो बेचारा नहीं है. अगर बेचारे कुछ है तो some IPs हैं.
I have no sympathy for JSW or anybody, but I am just trying to how we
from
can,
an international perspective. Anybody, if you are an outsider and you see that the rule of law is upheld in this country, भले देर आए लेकिन दुरुस्त आए, people cannot get away with murder, and the courts of this land will step in if required and reset the clock if need be. It gives much more confidence to a foreigner than, or even for a local investor, for that matter, any lender or whatever who want to put it, they know, okay, law is on your side. The promoters or RAs who become the new promoters, they can't, get away by doing wrong things ever, forever. Okay. So it is possibly the most positive signal in the entire IBC framework till now. Bhushan Steel, 5 years later, people will say, this is where the mentality changed. that you can't get away with murder.
Right. Okay. Got it.
Thank you. I know. It's a basically, if it is wrong thing done always. If you have not followed the law, always you are not followed. Yeah, I think there is no further raising of hands and we can close
Yeah.
the.
Any other question, if any?
Thank you, Raviji, for your insight, clarification.
There was one more question that was going around, and in other on the same topic when this debate used to go around, that if Supreme Court was using Article 142, why did it say liquidation? And it could have as well said, start the CRP again.
Hmm.
जब करना ही था तो why opt for liquidation? Why not for CRP again? Quite a few people raised this query. But yeah. So you need to understand what is
What do
Article
you
142.
think? What do you think? Actually, it should have been started again.
No, not what I think. I heard this, that a lot of people had this grievance. Okay, first they had this Bechara JSW. Then, of course, they came, okay, if it had to be done, why liquidation? Liquidation means gone case. Now, that is totally wrong thinking. Liquidation doesn't mean end of the world. It doesn't mean that at all.
No, it
Because
also is kind of a resolution.
Sale as a going concern is always available, and if it's a hugely valuable asset, there will be, like somebody said, good hai, to makhiyan to aayegi.
Right.
So there were other resolution applicants who didn't win at that time. They will come, or maybe somebody else will come. We don't know. But definitely there will be somebody interested in takeover at the right price. So that is not the problem, that liquidation by itself is the end of the road. But Article 142, could it have been used to reorder CRP instead of liquidation? Now, there is something very interesting about 142. 142 is not just an article in the Constitution. There is a presidential order of 1954 which tells how 142 is to be used. Almost nobody is aware of it.
No.
Okay. Now that order clearly says, and as per the terms of that presidential order, which is as good as the Constitution, that when there is a provision in law as to what can be done in a certain set, then even use of 142 has to be within the four corners of that only.
Okay.
So, Section 31, right, which talks of liquidation, that if you don't receive a resolution plan, it is still laid out very clearly in IBC. कि ये तो कब liquidation. That's it. There is no provision of going back to CRP at all.
Oh, okay.
Okay. And why did the Supreme Court itself not order the liquidation? It directed the NCLT to order. And it's now before the NCLT, they are also hearing it as an application. Why? Again, that presidential order says so. Just because you are Supreme Court, you cannot use power which is not given to you. When there is a process in law, so the same thing which Supreme Court was trying to tell through this judgment, that procedure has to be mandatorily followed, applied also to itself.
Okay.
So they followed the procedure exactly as per law.
They cannot rewrite the law under 142.
They cannot rewrite. 142 is where there are gaps in the law, you can fulfill it, but you cannot. Okay, there are certain cases. Even that same presidential order says if there is no provision in any law, then their additional discretion comes into play. Now, under IBC, there is a clear provision. If the resolution plan is non-compliant, what should happen? Liquidation. It is written in the law. Either the resolution plan doesn't, NCLT doesn't get it in time, or it finds it not compliant with law, or there is a failure in implementation. In all three cases, end result liquidation. Now the Article 142 was used to order the similar order was there in Jet Airways. That's also use of 142. Same thing, telling the NCLT order liquidation. Now, that's a direction given by a superior court to a subordinate court. But it's not exercise of power of the subordinate court. It still has to go. That is the procedure. Even courts have to follow it.
Very interesting.
What is to review the order? What is asked that whether the proper law is followed process, and they have to review and then give necessary direction.
Yes. So even Article 142 has is equivalent, you can say, of regulations.
Yeah, very nice. Very nicely explained, Ganti Saab. And I'm
Really
sure that,
appreciate.
and I'm sure that Bhushan Steel will get a better resolution now.
It will.
It will.
It will get a better resolution. It may take a little time, doesn't matter. Company to chal rahi hai na. See, RPs don't run companies. Let's be honest about it.
Correct.
They are run by the operating people who are already there.
Correct.
And usually they are good people. Bhushan was a running company even when it defaulted on the financial side, but it was never a problem on the operations side.
True.
Right. Okay. Thank you. Any other thing, or we can close? I think we can close.
Yeah. Thank you, Dipti ji.
Thank you. Thank you, Mr. Ganti. Thanks a lot. Thank you, Mr. John. Thanks a
Thank
lot.
you, Disha. Good presentation.
So,
Yeah. Thank you. Thank you,
Thanks
Mr.
a lot.
Mahesh. Thank you. Mr. Mahesh has said thank you to Mr. Ganti. Thanks a lot. Thanks, everyone. Bye.
Bye.
Bye.